Hello, everyone, and welcome to our Women in Sectional Title webinar. I am just loving the engagement on this platform. Thank you very much to all of you who are sending me everything from what you want on this webinar to telling me about your career path in the sectional title industry, navigating around difficult clients. I appreciate everything that you send, so keep them coming. We really, really do want to see us sharing, growing, and learning together on the Women in Sectional Title platform. Keeping us alive and kicking, thank you very much to Sectional Title Solutions, We Connect You, and PKF Octagon. Without you guys, we wouldn't be anywhere, so we do appreciate all of that. And speaking about our sponsors, I'd like to mention the We Connect You Engage in-person events. They had one yesterday, and by all accounts, it really went well. Let me tell you more about these events, where they'll be hosted. So on the 21st of February, the event will be in Pretoria. That's We Connect You Engage. So you can go on and have a look. And if you want to go there, I'm sure you're able to. In Tebeka, 4th of March. In Durban, the 6th of March. In Cape Town, the 14th of March. And in Bloemfontein on the 18th of March. So you can take an opportunity to go there. They host these in-person events to talk through business strategies, to talk through insights in the industry, and just to garner the support, really, of our amazing sectional title industry. So really well worthwhile. So today, we're talking about the Sectional Title Advisory Council and certain insights that came out of a recent meeting that was held with this council. Now, for some time, the Sectional Title Advisory Council has been on the cards. In fact, since October 2016, when the sectional title legislation was actually promulgated, there was a creation, the creation of this council legislatively was brought forward in Section 18 of the Sectional Title Schemes Management Act. So today, what I want to do is I'm going to give you a type of a lecture. So you grab your pen or your computer. A more formal presentation will be given by me on the 7th of March for the National Association of Managing Agents at Cedar Woods. So if you'd like to attend that, you're also welcome to. And that will be available after the 7th of March for any of you. So right now we're talking about these insights. The fact that the council took so long to be formed properly, and the fact that we've only been approached now made us forget a little bit about this importance of this advisory council. So I'd like to take you through everything. It was really with great excitement that I received a request to attend a meeting on the 5th of February from this advisory council, together with other stakeholders. That was Justin Mason from Sectional Title Solutions, another sponsor of ours. It was with Graham Paddock and Jennifer Paddock, myself, also the representatives of SAPOA and the Federation of the Urban Poor. So let's convey to you a couple of points that were raised from the meeting in terms of what the council has already been working on. And then I'm going to also include things that we raised and brought up. You're very welcome to questions on the chat box there as well. But I want to establish the source of this committee, and I'm going to do so by looking at Section 18 of the Sectional Title Schemes Management Act. Who is this council? What are they there for? So Section 18 says, there is hereby established a Sectional Title Schemes Management Advisory Council, which must, A, make recommendations to the minister concerning any matter specified in Section 19, which talks about the Sectional Titles Act, where the minister may make regulations. And who's the minister they're talking about? The Minister of Human Settlements, who as at 3rd of December 2024, was Nathembisile Simelane, that she was appointed. So also, the Advisory Council must keep the implementation of this Act and regulations under regular review and must make recommendations to the Minister with regard to any amendments thereof or any other action which may be advisable, and C, advise the Minister on any matter referred to it by the Minister. So we all know the Minister of Human Settlements is the Minister regulating sectional title and community schemes as well. So the Advisory Council consists of not more than 7, but not less than 5 members, of whom 1 member is the Chief Ombud, who must act as the chairperson. 1 must be a senior official of the department of the Director General. The remainder must be persons appointed by the Minister who must have the skills, knowledge, and experience in the management of a range of type of schemes. So we do have 4 of those, and those are the people we met. That was Advocate Nomondi January, Mr. Iqbal Matala, Ms. Chenwana, and Mr. De Beer. They were at this meeting as well. So they are those 4 people. If we look further into it, a member of this advisory council holds office for a period of 3 years. Now, our advisory council was, the members were appointed on the 1st of April 2023, and their appointment ends on the 31st of March 2026. So we know they're in for that particular time period. The other thing that I wanted to tell you, and something that they made very clear, is that they're not part of CSOS. The Advisory Council is a specific separate council that will only directly meet with the Minister. So CSOS, the only capacity that CSOS are there in is an administrative capacity to undertake any kind of administrative work, taking minutes, arranging meetings, and that for the Advisory Council. They don't hold any sway, and they're certainly not involved in any decision making. So that is the real line. They've got a direct line to the Minister, which is pretty, I think, pretty important. So having established that, let's now talk about the council's work to date and what they told us, and perhaps we can also, in the meantime, at the end of this, you can also bring up things that you would think should go to the Advisory Council, and I'm very, very happy to prepare something for the Advisory Council on your behalf if necessary. Bear in mind, this is just the start of the engagement with the industry. So let's take it step by step, shall we? Okay, so the council's work to date, and I want to get this out of the way first of all, because generally the council's work in terms of the Sectional Title Schemes Management Act is limited to sectional title, but they did make clear to us that they would take suggestions about homeowners associations and community schemes also to the Minister of Human Settlements, because they are the regulatory body over that. And the one thing that was raised is that, number one, many developers in these homeowners associations are putting in clauses into their memorandum of incorporation where there is an assignment of powers and functions to the homeowners association, a master HOA. And that has been causing some trouble in our homeowners associations, where there's an abuse of power, where the developer's too close to this master homeowners association, and the body corporates in these layered developments where you've got homeowners association and sectional title schemes. The bodies corporate are losing their identity, and the delegation of these powers is taken away from the Sectional Titles Schemes Management Act and everything from that body corporate. So they are going to look at that. Something that I raised about homeowners associations with them is that I truly believe that there needs to be a separate act dealing with homeowners associations. I've always said that the Companies Act is a clumsy and awkward vehicle to deal with property management. And this goes back many, many years since I first started working with homeowners associations. We see more and more disputes coming up in these homeowners associations where people feel that they are freehold, so they're like a different category and nothing applies to them, even a memorandum of incorporation. So hopefully they'll take that into account and see where we can go from there. So that is the first thing that we spoke about. The council has also been looking at POPI, and more specifically, Section 3(1)(n) of the Sectional Title Schemes Management Act, and I'll take you through that now. This is a good time to also refresh our knowledge on all of these things. So Section 3(1)(n) of the Sectional Title Schemes Management Act says that a body corporate must perform functions entrusted under this Act, and such functions shall include to comply with any reasonable request for the names and addresses of the persons who are the trustees of the body corporate in terms of the rules, or who are the members of the body corporate. So now with POPI, we've always had, a few people saying, yes, but we want to ask the managing agent for the names and addresses of all the owners because we want to oust the trustees. There's always a problem. Can we get it? And everybody, all the managing agents I know will always send something saying, well, POPI, you're not allowed this, you're not allowed that. And it's very easy to hide behind POPI. So the reason that the council is working on this is because there are also contradictory provisions in Management Rule 27. So Section 3(1)(n) says that there must be a reasonable request. So we need to understand what is reasonable. So that's what they want to flesh out with as an advisory council. And because Management Rule 27(4) says on receiving a written request, the body corporate must make the records and documents referred to in this rule available for inspection by a member or a registered bondholder. And that includes things like trustees' details, tenants' details, ID numbers, addresses. So, there's a bit of a disconnect between Section 3(1)(n) and certainly Management Rule 27. And that is what they want to clear up for once and for all. By the way, my attitude and opinion on that is if an owner would like the details of trustees or other members for the purpose of sending everybody emails surrounding their concerns with the running or operational management of that body corporate, that does constitute a reasonable request. And I think that has been upheld in one or two decisions also at the Ombuds office. Okay, so that is POPI. Then we go on to something very interesting, and that is the appointment of administrators. They've also been doing work on this. And I know when I was working with the legal department at the CSOS for the new amendments, and we have done a webinar on that previously, the situation regarding administrators was raised by them. And there was a move towards taking this away from the Magistrates Court. You'll remember Section 16 of the STSMA talks about administration. And initially, it was the High Court that was able to appoint administrators. Then the law was amended and it said, now you can go to the Magistrates Court, and that is the position now. But all too often, I find with administrators, the administrators are, a lot of them are not of the best caliber. Some of them are, by the way, but many of them are not, and they've just got the body corporates into these continuous cycles of debt. And it really doesn't make a difference whether you have to go back to court or not. Then it's not great. So what we're saying with this now is that the Advisory Council is saying perhaps the CSOS should have, like they've got a panel of executive managing agents, so they should have a panel of administrators who become trusted, credible, and that we can look to go under administration. Just to refresh your memories, a body corporate under Section 16, a local municipality. Can you imagine? I mean, the municipality, you can't even get them to do their own jobs now. They're going to get involved with administrators. A judgment creditor of the body corporate or any owner may apply to a magistrate's court for the appointment of a suitably qualified and independent person to serve as the administrator of the body corporate. And then it talks about that person coming back and giving report backs to the court every couple of months for a fixed, they're there for a fixed period, but they must give reports. So Marianne Tuck says, will the application then go to the CSOS to appoint the administrator? Yeah, that's the idea. The idea is that just as the CSOS can appoint executive managing agents, the CSOS may be then allowed to appoint administrators that are vetted and, that they're suitably qualified. What is suitably qualified? I mean, at the end of the day, you need somebody with huge skills to go into a building. Not only must they have a few bulletproof vests at their disposal, but they must have knowledge and understanding and a good manner and accounting background. So that is important. Something that I raised, an article that I raised at this advisory council meeting, I find so interesting. And if any of you want this copy of this article, please email me. It's an article written by Ranjit Purushottam. He's a colleague of mine, another attorney in Durban. And he wrote quite a scathing article about placing poverty-stricken buildings under an administration. And of course, that's one of the key factors to placing a building under administration, is that they're not financially stable and that things are just going downhill. And he says that Section 16, this administration section, is invalid and inconsistent with the Constitution until it's amended. And why he's saying that is that he says he doesn't believe that these buildings are being mismanaged. He believes that sectional title is actually not correct, not the correct institution for poverty-stricken buildings. And he's basically saying that sectional title developments are only appropriate for individuals with regular incomes or sufficient capital to meet their obligations to the body corporate. They are not for the poor, unemployed, recipients of social grants or social housing, where these have been made for, these buildings have been dealt with by government and then converted into sectional title buildings. And I think that is so, so true. He says that unit owners must have the financial wherewithal to contribute towards the upkeep of the scheme. And the trustees must have the requisite financial literacy, knowledge, and skills to administer the body corporate. The state is aware that the poor do not possess these attributes, yet it insists on herding them into these schemes. There is mismanagement in the running of these affairs because the residents have been forced into schemes that are regulated by laws that they simply do not understand. And he is also saying that it follows that when the impecunious are placed in sectional title schemes, the administrative and financial affairs of the body corporate will of necessity spiral into disarray. It is a foreseeable and natural extension of the turmoil that is an intrinsic part of their lives. And why put them, why impose useless and costly administrators on these type of buildings when it's never going to work in the first place? And I thought that this is I agree with it. I think it's a fabulous article, and I think we need to look at that. And that is what I put to the council as well about administration. Then we talked about registration of schemes. That's your next point. So, as at the end or the beginning of 2024, we had 30,000 schemes registered with the CSOS. We're talking about registration with the CSOS out of an approximate 70,000 schemes that we have now. I think probably in the last year, we've upped that, but certainly not up to 70,000 schemes. So we spoke about how do we encourage people to register? How do we make sure that these buildings that are sort of recalcitrant, that say, well, we're not going to register with CSOS, how do we manage them? And something that came up at this meeting was get the banks involved. The banks granting bonds in complexes should not be granting bonds in a complex that is unregistered. And that is certainly, for me, the easiest way that you're going to get an uptake of buildings that become registered. So that was something they're working on. Also, the next point, penalties in sectional title schemes, something that does seem to be sort of an ad hoc type of thing where every complex is giving in different amounts for different penalties and offences. There's not one set standard across the board, and certainly the council is aware of that, and they do definitely want to get involved with that. Then the other thing that that has been a top of mind for them would be executive managing agents. And that is Regulation 28 and 21 on executive managing agents and the appointment of these agents. We have spoken about this before on this platform, but for those of you who haven't heard, they are going to really press the role of executive managing agents. And the Advisory Council is very much for the appointment of executive managing agents in schemes, particularly problematic schemes, where things need to be grabbed by the scruff of their neck and taken forward. Everywhere in the Act where they mention managing agents, they're going to also say / executive managing agents in any amendments going forward now. And the role of the executive managing agent, I am certainly seeing more managing agents taking up this role and charging anybody as well, for this additional function. So I think that, I think it's an important part of where we're going. But executive managing agents, they want to also start looking at regularizing fees. The fee structure must be higher, but looking at taking, all of that over as well. Let me have a look here. Sorry, I just wanted to see Greg. Let's see, Greg. Hi, Greg. Scott, can you demystify the BBE certificate requirement sent by CSOS for the appointment to the executive managing agent panel? I wouldn't be able to do that for you on this platform, but certainly we can go into that. And something that I must say to you guys as well, that I've had conversations at CSOS regarding BEE and BEE requirements in complexes with regard to service providers, bringing that in to say that you have to have a certain level of BEE when it comes to bringing service providers into the complex. There are also discussions which started, which I've hopefully have ended because I don't see them going anywhere, talking about actual trustees being of certain BEE qualification. So you'd have X amount of underprivileged trustees on your board of trustees. And that, I think, and I said to them, trustees, it's a volunteer job. So at the end of the day, you certainly can't go and put that kind of BEE requirements. What if people say, well, we don't have enough Indian people, we don't have enough Black people, we don't have enough white people. I think I don't think that's going to fly at all. So but Greg, I'll look at that and I'll come back to you. That's okay. Right, so we go on and we talk about Graham Paddock at the meeting raised the importance of destruction of schemes. That's something that he's looking at. And let me read that to you. That is section 17 now of the Act. It says, the building comprised in a scheme is for the purpose of this Act deemed to be destroyed, A, upon the physical destruction of the building, B, when the owners, by unanimous resolution so determine, and all holders of registered sectional mortgage bonds and the persons with registered real rights concerned agree thereto in writing, or C, when the court is satisfied that having regard to all the circumstances, it is just and equitable that the building must be considered to have been destroyed and makes an order to that effect. So the minute you're looking at the section, and originally when I looked at the section, it was very much in your head that this is where there's been subsidence and a whole building is damaged, or, something explodes and blows up and it blows up the building and it's more physical thing. But actually we were involved in a case many years ago in the Cape where we brought an application to the High Court to deem a building destroyed due to the fact that it was a hijacked building. There were drug dealers who had taken over the building. It was really, really, it had been absolutely decimated by a whole lot of circumstances. So there we got an order, deemed destruction. But Graham has brought in something else where you can deem a building destroyed, is where it's almost like you're winding up a building. That's it, folks. It won't even help for this building to go under administration. we're just going to, wind this building up, and it's an elegant kind of winding up of a sequestrated business, a person, or a liquidated business. So, yeah, I think that is going to be something, and that's something that he seems to feel very strongly about. And I think particularly in the socio-economic climate that we're in, I think that is something that is going to be very interesting indeed. So that was from the council's point of view. That was what everybody was talking about. And I think that was quite interesting. Let me have a look. Redme says, hi Marina, thanks to you and all for the webinar. That is interesting to hear the point of EMAs. Will there perhaps be a forum or contact email where owners can ask for CSOS to investigate a scheme when things are being badly done, slack governance not upheld, and some owners are benefiting at the cost of the scheme or other owners? Well, certainly CSOS does have they do have certain investigative powers, but it's usually when things are brought to them rather than them going and investigating a scheme. There's got to be some sort of proposal that's brought to them. I know that they have gone into the inner city to look at buildings that have been hijacked, and to that extent, you will start seeing their powers increasing. That's what I think. At the moment, no, but managing agents are starting to play that role and taking things to CSOS on behalf of those buildings. Okay, then a couple of things that I raised. The first thing that I raised was the situation regarding arrear levies. We need some urgent intervention, certainly from the banks on arrear levies. And I think that is something that has to be top of mind, because I'm seeing arrear levies tripling, quadrupling in many of the buildings where I'm involved. And I think that at the end of the day, the banks have to come to the party. I mean, in overseas jurisdictions where a bank grants a bond, they take a lot more responsibility than our banks are taking at the moment for the repayment of that bond. If the bond is not repaid, and for example, you've got units or this sort of community living environment, the levies for that need to be the bank's part responsibility too. It's very easy to grant a bond. If you haven't done your homework and you can see that, or somebody's not paying their levies, and we've got arrears in 100,000, 200,000, 300,000. I've got a sale in the High Court. Now we're bringing a 46 application in the High Court. 350,000 Rand the guy owns. We have to have banks' cooperation in that event. You can't say, well, the bank says, well, sell it, but we want our reserve price. In other words, we want what is owing on the bond. And we're not prepared to go down on that. We're not prepared to, do anything about the levy payment or even absorb part of the levy payment. And they do that overseas. So we're looking to start a lobby group. Very happy for anybody who'd like to join me in that and to start lobbying the banks. And I think certainly from a women in sectional title perspective, from a NAMA perspective, and certainly from this council's perspective, that is something that they may be able to also take forward. Also the story with if you're in arrears with your levies as a trustee, that needs to come back into our legislation. You cannot be in arrears and hold management positions, because you're not going to hand over anybody who owes money if you're a trustee who himself or herself owes some money. So that needs to be tightened up. And yes, that's NOLA. We can definitely send the recordings to you. If you just email us, we'll send the recording to you of this webinar as well. So yeah, arrear levies, we can talk about that if anyone's got any questions. I understand the frustration. The courts are frustrating. We deal with sheriffs every day. It's very, very tough. But the one chap there from the Federation of the Urban Poor, who was at this advisory council, said, that's what CSOS is for. CSOS should be there to manage the collection of money. They should be there to handle arrears. Well, they're not there yet. Certainly, they're not there yet. And I think that at the end of the day, at this stage, the courts are the only way to move forward. And as an attorney working in that space, it's highly frustrating. I know that There've also been people who say, well, then they're not allowed access to the complex if they're in arrears. Or we, as the body corporate, are going to switch off the electricity if they're in arrears. Those things are illegal. We do apply to the courts to disconnect electricity, and some judges are granting those applications, and some judges are relying on the Lion Ridge case, which says that it must be in your rules that you can approach the court to disconnect electricity. Then I know some people who are wanting to pop that onto their electricity meters to say you're not allowed to buy more electricity if you're in arrears with your levies. The CSOS has quite unequivocally said that that is illegal and that people are not allowed to do that. So that leaves a body corporate in a really, really difficult position. And we're seeing a whole lot of body corporates facing major, major problems. Some practical things that we're trying is to ask the body corporate ask the debtor if we can put a tenant into their unit just to get some money back. Or if we can find private investors who will buy those units that are in distress. But again, if the bank doesn't come to the party, and the body corporate doesn't come to the party to decrease those levies, we're at an impasse, and I see it every day. Okay, something else that I raised that I think is pretty important would be the quorum requirements. I think the quorum requirements are too high. We've been moaning about this since the Act was promulgated, because I know that managing agents are always moaning that they have to postpone their meetings for a week because they don't get a quorum at a meeting. So, there needs to be some kind of acknowledgement. I mean, it's just creating dramas. I mean, a few of my managing agents just do it as a matter of course. They actually just set it in their diaries that they're also going to go there next week, and then things can pass. But we need to be practical, people. We need to say, well, listen to the people on the ground. And I think I'm getting a little bit tired of the voices of managing agents not being loud enough. I think you guys work with these things. A lot of you are on this webinar today. We have some trustees as well, but managing agents work with these things on the ground, and I think that's really important. Thanks, Karin. I see you're happy to get involved with lobbying the banks. And also, I think Greg also said that, so thank you. Jenny says, thank you for the feedback. With regard to the recovery of arrears, would this council be able to assist in regulating the CSOS and courts on these proceedings? There are severe delays where parties cannot be held accountable for lack of services. The court's view and contest the wording of some of the CSOS orders, which prevents sectional title schemes from holding the guilty party liable for legal fees. It appears that the paying owners are being negatively impacted by these delays. So the role of the Advisory Council is certainly to alert the Minister to these problems, and then the Minister would advise on the regulations and sections of the Act that may or may not need to be changed. And they wouldn't be able to go to the CSOS directly. They're not allowed to do that at all. Can the point be changed? Nola says, sorry, let me just see what we're going. Can the point be changed in the Act where it says that managing agents take direction from trustees? This point empowers trustees that they're often arrogant or ignorant. The MA is the professional, not the trustees. Okay, well, sometimes I'm actually saying to the trustees and owners, you are actually the tail that wags the dogs, not the managing agents, because I do think that the trustees need more accountability. They need to understand they are accountable because they just fob things off on the managing agent. But I understand at the same time that it's extremely frustrating for managing agents to try to tell trustees what to do because they are the experts, and trustees just doing their own thing. But at the end of the day, the managing agent is just that, an agent. And the trustees are the ones actually in charge. And I don't think that's ever going to happen. Nola, absolutely. Edna says it also allows managing agents to hide behind the fact that trustees never ask them to do anything. Yeah. Look, I think it's quite tricky for managing agents and trustees to. It brings me to the next point that I raised at this council meeting, and that is that for too long we have no legislation surrounding the education of trustees. And I think that's what you guys are really getting at, isn't it? It's the fact that you get these guys in charge of the body corporate. They've got other work to do. They're not particularly interested in the provisions of the Act and keeping to the prescriptive nature of the Sectional Title Schemes Management Act. They rather want to treat it as a guideline. Trustees need to be educated, so as soon as they're appointed trustees, within a certain time frame, like in our overseas legislation, they need to do a course or some training. They need to receive a certificate or some certification that they've understood the gravitas of the role that they've taken on. It doesn't have to be a 6-month course, but it can't be a 1-day course either. It must be something. And if you haven't done that course, then you will automatically be disqualified as a trustee. Training. I think that's, we can't afford the slack governance anymore at the end of the day. Sandy Hammond, nice to see you on board here, Sandy. Thank you. If you can help with lobbying the banks, can't be in. Yes, the Banking Association of South Africa. Thanks, Sandy, definitely. Marion says, how many of these council members are owners in sectional title schemes? That's quite an interesting question, Marion, because actually out of the 4 there, 3 of them were owners in sectional title schemes. And they were talking about their very own experiences in the schemes, which I think helps a heck of a lot. So that was it. Good, yes. Trustees are by and large not interested in becoming educated in affairs. They then become bullied by certain owners who seem to know what they are saying. And Veet says, agree training for trustees imperative, but then how many owners would sign up? Well, owners don't need to sign up, but certainly if you're going to be a trustee, you definitely do need to sign up. Okay, so we've spoken about arrear levies, quorum requirements, trustee education. Then also we spoke a little bit about short-term letting, because I think that's something that the council needs to hear, and I sent them something afterwards about that too. So short-term letting, I don't know if you may know, I actually was on 702 the other day talking about the latest happenings in the short-term letting space with Airbnbs. And what's happened is the Department of Tourism have certainly taken this on over the last couple of years to look at some sort of regulation on Airbnbs in the South African space and context, because many countries all over the world have started regulating short-term letting in a big way. Short-term letting has started decimating your hotel and tourism industry. It's had a very bad impact on long-term rentals, particularly in a place like Cape Town. And it's had an impact also on the owners who are living in sectional title schemes where you've got security issues, you've got people walking up and down, you don't know who they are. Your nice, quiet residential apartment block has now become a hotel where, people are not happy about it. So there is a balance to be had, because short-term letting also brings in tourism, and certainly it bolsters the income of those people who are living in sectional title schemes and have now become used to it. But the Tourism Board is adamant, the Department of Tourism is adamant that they're going to start doing.
That's from Avrios directly, because we changed from Invest.
Sorry, I think there's somebody who's talking. I wonder if you could mute yourselves. So I think the sectional, from an Airbnb point of view, they're going to start capping how many months you can actually look at Airbnb your unit out for. So that's between 30 and 60 days overseas, 30, 60, sometimes 90 days. In places like Florence, for example, they banned Airbnb in the city centre totally, because it's just caused too many issues for the residents and for their long-term rentals. So long-term rentals, you're going to see, and I saw in the Real Estate Institute magazine, there was an article yesterday about the increase in long-term rentals. So now the council, how do we deal with this in sectional title buildings? Because sectional title buildings, we know there's the Paddock case, where it says that the body corporate, the trustee, the body corporate can make rules prohibiting short-term letting, and so far that's so good. But if the Board of Tourism says, yes, you're allowed to only have 2 months of letting it out, how does that impact on the rules that owners by 75% can make in their scheme at the moment. So the sectional title, the council seemed unsure of that, and it's certainly something that they're going to look into and advise. Aubrey says, I missed part of the presentation. Any news on allowing the body corporate to have additions to sections that will increase the PQ be rectified by body corporate and adding the expenses to the section's levy accounts? Yes, absolutely, Aubrey. There have been discussions about that, and that was also raised at this meeting because of what's happening with the new legislation, and the legal departments in CSOS are working on that. So what is proposed is that if somebody wants to extend their section, they will do so. They will get what? A special resolution to extend their section, which is the floor area or boundaries of the section. They will then need to go to a surveyor general within a certain time frame. I think it was within 60 days. They would have to go to the surveyor general, to a surveyor, to redraw the plans, because now all of a sudden your section is increased. So your PQ will be increased, which will mean that you will pay more levy and that you will have a greater voting right. If somebody doesn't do that, if an owner who's extending doesn't do that, then the body corporate will be allowed to appoint a surveyor, and whatever the fee is, they will be able to charge that owner. So that is what's coming in the proposed amendments, because at the moment, it's just a free-for-all. You get your special resolution to extend, you extend, and then you don't go to the surveyor. And as the position reflects now, the body corporate can't charge you an additional levy on that higher PQ until it's registered at the deeds office. You go to the surveyor, the surveyor general approves it, then it goes to the conveyancer registers it. So I think that's going to be fabulous. I think it's an absolutely brilliant amendment, which will come into our legislation very soon. Okay, let's just have a look here. What else does Annie? Annie says, having lived with short-term letting in a small block for years, it was a nightmare. Yeah, I can definitely resonate with that. Redme says, Marina, please, what is needed is legislation requiring owners to understand there is governing sectional title act. Owners being uninformed can be further misinformed. Where managing agents and trustees have their own agenda, no transparency, and not doing things according to regulations. Yeah, absolutely. This is important work. And it's certainly something that we all need to look at working on. So basically, in a nutshell, I've given you what was discussed. So you have a lovely insight as to what is going on. People are working hard. People do know what the problems are. But I was very impressed with the Advisory Council. I felt that they were open. They wanted to listen. They said that the mandate from the Minister of Human Settlements was to go out and speak to the stakeholders, consolidate the information, come back, and they're going to be doing that a lot going forward with other stakeholders as well. So I was impressed. I really was impressed. And, you know, being generally just being a totally optimistic person, I'm very, very hopeful that as we go ahead, I mean, we'll get places as we go ahead. I think we've come very, very far. If I think of my first early days in sectional title. Is there anybody who would like to ask a question? We've just got 1, 2 or 3 minutes left. If there's anybody who'd like to ask a question, please feel free to do so. Or if there are other messages, let me see. Is there a contact for Department of Human Settlements where a stakeholder can ask questions or offer suggestions? I think it would be a very good thing for you, you guys to utilize the Advisory Council, and certainly we can take any complaints or issues or problems to the Advisory Council, Women in Sectional Title. We can do that for you. So please, if you think of things that you'd like to put to the Advisory Council, don't be afraid. Just email us, email me. We're very, very happy to assist you to do that. Yeah. So email us. They're not going to take everybody's everybody's emails. I think they've got a lot of work to do, and they're dealing with, you can contact us here at WIST. It's marina@bbmlaw.co.za. You can email me directly with the greatest of pleasure. And as Lisa says, the recording of this webinar will be emailed to everyone who signed up on the newsletter. So good sharing information, always good. And thank you. Thanks very much to all of you who've enjoyed this webinar. I've enjoyed it. I love these webinars, and I enjoy liaising with you always. My door's always open. So please, feel free to contact me. Until next month, take care. Thank you so much.